This is Jonathan Perkins of Jonathan Perkins Injury Lawyers in Connecticut. I wanted to speak to you today about what you do if you're having a deposition where you're going to be deposed, and where, let's say you have a personal injury claim and the defense attorneys or counsel are going to question you in front of a court reporter and ask you questions, and you have to answer them under oath. What I tend almost always to tell people in that circumstance is, number one, that you should only answer the questions that the defense attorney asks you. Don't answer questions that they don't ask you. So that if you're asked what's your name, you should just tell what your name is. You should not tell the attorney where you live or to whom you're married or what you had for breakfast. So it's important at a deposition, frankly, if you're on the witness stand too, that you answer from opposing counsel only the questions that they ask. And it's not your job as a witness to explain why the answers are the way they are. That's the attorney's job. That's our job. Your job is simply to answer the questions asked. Also, if you don't understand a question, it's very important that you say that to the attorney asking the questions, and it's then incumbent upon him. He or she has to rephrase it as many times as necessary so that you can understand the question. Don't guess at to what a question means. You should really know before you answer. Also, and this is a problem that a lot of people have, if you don't know the answer to a question, you simply say, I don't know. Again, it's much better to do that than to guess at what an answer might be. In addition, if you're going to give an answer that's an approximation, in other words, you're saying it's about such and such, then you should go ahead and let the person asking questions know, so that that's on the record, the transcript of the deposition, that you're giving an answer which is approximate. So an example that I often give people is if you're sitting approximately 2 feet away from somebody and they ask how far are you sitting from that person, you shouldn't just say 2 feet unless you're really sure, unless you got a tape measure and check that it was 2 feet. Really, you have two options. You can say I don't know, because you don't know for sure. Or if you want to give an answer that's an approximation, you should say I'm not sure, but approximately 2 feet, or about, or more or less 2 feet. That way, you're not going to be led down a path where someone's claiming that you're lying about the distance being 2 feet when it's only approximately so. So those are some of the hints. There are others, and guides that you should follow when being asked questions at a deposition. This is Jonathan Perkins of Jonathan Perkins Injury Lawyers.